And good afternoon, everybody. This is Vinny Maletti with Maletti Law, the strongest name in law. The date now is June 16th, 2023. It is a beautiful Friday evening. So if you have any plans to go out, you definitely should go out and do something awesome to kick off your weekend. I'm sure you've had a long, crazy week. First and foremost, we would like you to go to the website, www.malettilaw.com. That's Miletti law.com, Miletti law.com. Sign up for the newsletter. Make sure at the YouTube channel you click the box subscribe now and you become a subscriber. We are a growing force, which is pretty impressive on how fast we're growing on YouTube lately. So, I mean, we've been growing up, we've been moving up in leaps and bounds. So I'm impressed, and I would like to thank everybody for subscribing and actively coming back. It's very helpful. And particularly since I make all these videos, I'm happy you guys and gals are actually like listening and watching them and hopefully learning something from them. Okay, so this video today was part of going to be a series of two videos. So I have a client who is very inquisitive, questions everything, and wants to really know about the process, but to like a really, um, but it's like a kind of like a really intimate understanding of it. So I've made a series so far, two videos. There may be more, but videos just to explain the process a little bit and why we do what we do. I'm sure other law firms do things other ways, but this is how Maletti Law does it. So this video, we're specifically going to speak about drafting a complaint. Drafting a complaint. Okay, so a complaint is that formal document that you prepare, that we prepare as attorneys, and we file it with the courts, whether it be state or federal, and we basically outline our case and we outline our allegations and how we need relief from the courts. Um, Certain jurisdictions have certain requirements. I find we practice in New York and New Jersey. We find that New Jersey has like a lot of little nuances that you should be aware of. And if you do hopefully use an attorney for your stuff in Jersey, and if you do, the attorney will know the nuances. It'll be routine for them. So just keep in mind that this video is exclusively going to speak about New York and state court. So it's going to exclusively speak about New York courts and state court. We're talking about Kings County, Queens, Staten Italy, known as Richmond County, the Bronx, even full the state, right? Also as well, Buffalo, Oneida County, Chenango County, Suffolk, Nassau. You can pretty much apply these rules everywhere, but so this is specifically for the state, whether it be the city area, the five boroughs, or it be Greater New York. Okay, so let's get down to it. So the complaint, right? So here at Maletti Law, I like to have a complaint in a certain way. To me, it's a very linear fashion, a complaint. So complaints have specific categories. You have, your preliminary statement. You have your section about jurisdiction and venue, section about the parties. You have your section about the actual facts. Then you have your causes of action. Then you have your prayer. And then, you have the certifications and everything at the end. But what does that come out to? Like six sections or something? Maybe it comes out to like six sections. So here I like to have all the complaints in a very linear fashion, right? So, and you'll see when the video was edited, obviously you'll see this. I'll share the screen with this one. So as you go down this, so what you are looking here is a draft document. It's just a template. It's for a discrimination case. The plaintiffs, when they want to bring some kind of employment, harassment, retaliation claim, this is what the model that we would use to basically build your document, right? So terminology, plaintiff is the person who is filing. Here at Maletti Law, we usually represent defendants. We usually represent the businesses. We usually represent the employers. There are times where we do represent the employees. So when we represent the employees, they are typically the ones suing the employer. So the employees would be the plaintiff. It is the plaintiff versus the defendant. Okay. So sometimes the plaintiff goes by the name petitioner. Sometimes it could be the complainant, depending on the forum. But for here, let's just say plaintiff. So you have the draft complaint. So you go back and forth with your plaintiff, right? And your client, and you have this conversation of the facts you need to put in there. You always start with the preliminary statement. The preliminary statement is basically this summary. You usually, in my opinion, do this last. The preliminary statement is just something to catch the reader, to catch the judge, so they don't get bored reading your complaint. Not that I think a judge reads a complaint, it could just be a clerk reading or whatever. It's just this is your exciting meat that you lure someone in. So you're very straightforward here. You're just, this is an action seeking this. This is a very high level of the facts here. This is a very high level of the causes of action. This is what we're looking for, as set forth below. And it's just the preliminary statement is just a very, it's just a very, what's what I'm looking for? Like, it should be something exciting for the reader to make them excited to read the rest of the complaint. I don't believe that these things should be boring. I don't believe that they should be super formal. I believe they should be more, I mean, you have to follow formalities, right? But I do believe they should be more entertaining because, I mean, you are dealing with human beings that are reading this, right? Life is not fully chat GTP yet, so, we still have some things to do. So you get to the preliminary statement. You'll come back to that last, in my opinion. So let's get down to it. So then you go into the parties. The parties are just what that is, the parties to the action. Who's the plaintiff? Who's the defendant? Where's the plaintiff from? What does the plaintiff do? What gives jurisdiction over the plaintiff here? Jurisdiction is a term to define the court's power over the individual, the court's power to hear cases. What is the jurisdiction? What is the law that applies? What makes this person able to come here, right? So that has to do with the parties. This is where you'll say Vinnie Maletti, an employee, working for a defendant who resides in Kings County, who resides in Queens County. Then you introduce the defendants. Defendant, the law offices of Vincent Maletti. Maletti Law is a professional corporation that is registered in New York City, has a principal office in Astoria, and is the defendant in this action herein. Sometimes you have third parties. You could just say, non-party Flex Maletti is a dog. He's the chief wolf, the welcoming officer of the firm, and he's also named in here as well. So you would introduce the parties. Next section down, you have the jurisdiction and venue. Jurisdiction is we're discussing why this law applies, why the laws of New York apply here, why this court is the proper court. So jurisdiction could be based on, where the party lives, 301, jurisdiction where the party lives, doing business in the location, section 302, which is, I believe, is also known as a long arm, if we use that word anymore in law school. So that's the jurisdiction, what enables the court to be able to enforce this action on these people and to bring these parties to court. Venue is something else. Venue is essentially what is the proper forum, what is the proper playground for us to play this game in. Is the proper playground in Kings County? Is it in Queens County? Is it in Staten Island County, also known as Richmond? Is it in Bronx County? Is it in Strong Island? Is it in Nassau? Is it in Suffolk? Is it in Oneida, whatever it's called, Chenega County, or whatever all those counties are upstate? That is basically the playground in which you play in. What's the proper playground, right? That's what venue is. So you went through jurisdiction, you went through venue, you went through parties. Now we go into the factual allegations. I have a very specific method in which I do this. I love timeline allegations. I like on this date, this happened. On this date, this happened. On this date, this happened. Because you want to make it linear, easy to read. I like to also, one of my clients was questioning why I sometimes repeat myself. A strong case has a lot of really accurate, a lot of really specific information, a strong case, right? Sometimes for the future, you don't want to go digging in these lawsuits and these complaints. So what do? You repeat yourself in a way to where you'll maybe have a catch-all paragraph. So let's say at some point in paragraph 11, let's just say, you'll talk about all the adverse acts that the plaintiff was subjected to. So you might collectively refer to this in the end, as wrongful acts. So for the rest of the complaint, when you say wrongful acts, you mean all these things. Sometimes there's a subset. Sometimes those wrongful acts might not be retaliatory. They might be, discriminatory, or they might not be discriminatory but be retaliatory. So you might have to make a certain subsection. So you might have 5 bad acts that you say this is what this claim is about. So you mention 5 bad acts and you categorize them as the bad acts. Then you say, these acts in particular are retaliatory. So though they are bad acts, they're also retaliatory acts. So now you would repeat those items into retaliatory acts. What you're doing is you're creating a structure that the court can pull from in the future. You're creating a structure that's easy for the court to understand, easy for the court to follow, and to move forward on. And that's critical because the person that's going to read your complaint, that complaint should be a script. You should write that complaint. My opinion, other attorneys do differently. My opinion, that complaint should be a script for Netflix. That complaint should be a very interesting read for the judge, that the judge wants to read your case, the judge feels sympathetic for you, and the judge moves forward. And that is, in my opinion, that's key because you're dealing with human beings, and human beings don't want to be bored out of their face. They want to read cool shit, okay? And a lot of cool shit comes from, really great drafting. So if you want a judge to read, if you want a clerk to read, if you want someone to pay attention, you got to have great drafting that draws them in. So that's your factual allegations. I like them in a linear fashion. You always end off with some statement about, that this transgression is continuing today, that, we continue to have issues and whatever the case is. So again, very linear fashion from day one to today. And that's when you go right into your causes of action. So now you have your causes of action. So remember, we went through so far, and I'm just going through, we went through the preliminary statement, we went through the parties, we went through the jurisdiction and venue, we went through the factual allegations. Now we're going to go through the causes of action. The causes of action, that is the specific law you are citing to. You are saying this is well, we're using discrimination in this case, right? So this is a case based on discrimination. The first paragraph, the plaintiff alleges everything previously. Second paragraph, plaintiff was an employee pursuant to this statute. Third paragraph, defendant was an employer pursuant to this statute. Fourth paragraph, discrimination is, an adverse act based on a protected category in which the employer did and caused damages, right? So now here's the elements of discrimination. You outline the general elements. Now you're outlining the specific facts. As stated previously, the client meets all the facts here. Step one, client was an employee. Step two, client suffered discriminatory acts when wrongful acts were taken against him. Step three, client was terminated. Step four, damages. So now you repeated all the elements, but you tied them into your claim. And then you finish off always with kind of like a templated paragraph, due to the direct and proximate cause, due to the direct damages suffered as a result of the wrongful acts, the client, continues to suffer damages to this day and seeks relief. Then you go into your second cause of action, your third cause of action, and you repeat this. Again, you're moving in that linear fashion. You're building every piece, right? So with every cause of action, you are outlining the elements. You are expressing how these elements apply, how they are aligned with your case, and then you are saying how they damage your client. You are saying the same structure over and over and over again because that's the correct structure. If you want to survive some kind of dismissal or some kind of preemptive motion, which is for another video, but if you want to survive at the very beginning, you got to present enough facts to just kind of get forward. You don't have to prove everything perfectly. You don't have to have all your facts in hand. A lot of facts you won't even get until discovery. So, but you got to make sense. You can't go in there with gobbledygook. You got to make sense, right? So now we went through the causes of action. At the end of the causes of action, we go into what's known as the prayer for relief. Okay, so the prayer for relief is your prayer. What pray can the court do for me? How can the court help me today? I pray that this court should give me this. And that's where you put them all. Maybe you want a declaration in which the court declares that the employee was naughty. Maybe you want injunctive relief, that the employer puts an injunction. Injunction is just a fancy word for an order, for a command, where the court commands that the employee stops being an asshole. An injunction, the employee shouldn't be an asshole. Then maybe you might say, I got damages, what are my damages? I got some back pay, I got some front pay, I got some consequential damages, I lost my job, and at the same time, my cat ran away because I was freaking out at the house and I had to go chase my cat. And because I chased my cat, I couldn't pay my mortgage on time and my house was foreclosed on and just all kinds of nonsense, right? So that's where you have your prayer for relief for everything. And then finally, after that, you have your, I like to do it. Some attorneys don't, some attorneys do. I like to have a jury demand, and you just say, plaintiff hereby demands a jury trial for discuss all damages herein. And then you have your signature, respectfully submitted or disrespectfully submitted if you're really frustrated. The date, which there's something, I don't know, I only do it because it's apparently this cultural thing here. It says, next to date, it's always, city and state and then the date underneath it. So it doesn't really line up. Very funny, very unusual cultural thing we do here. Not really sure. Um, but yeah, so then you put your date, your signature. Now, this is something I like to do. Verification page. I love to verify. I need a verification page afterwards, and I'll tell you why. Because historically, in the past, I have had this happen to me before. As an attorney, even though an affirmation, is supposed to be good for purposes of like discussing a claim, discussing the plaintiff's claim, the facts, you affirm that the facts are true and correct. Why? Because your plaintiff has trained you, because your plaintiff has walked you through everything, because your plaintiff gave you emails, your plaintiff gave you all the information you need. Bump kiss. Courts don't give a shit. Courts will, whenever they can, argue that you're not a first-hand person. You can't testify to nothing. Okay, you're an attorney. Okay, you gave this affirmation. Great, we love it. It's not going to work. You got to get something that has been attested to, has been affirmed, an affidavit, has been disclosed declared by the plaintiff. Now, when you verify your complaint, it serves kind of the same function. So it the court will read the complaint as if it came directly from the plaintiff, him or herself, as if they were the one conveying the messages when it's verified. So I think a verified complaint and a verified answer for that matter, which we'll talk about in the next video, I feel those are very important. And I think, I think that you always want to have your complaint verified. It gives it takes away one argument from the other side, and it also gives the court the comfort it needs to know that they're getting firsthand information, accurate, correct information. Kind of shouldn't be necessary, right? Because the whole purpose of an affirmation is to have to avoid like these kind of really strict formalities. But old habits die hard, and a lot of times when judges have a really busy caseload, they'll use whatever they could use to kind of like walk away from, to kind of like minimize their caseload. So you want to avoid that, right? So I would just say get it verified, get your client to sign it, get your client to get it notarized. All good. It doesn't bother nobody. So that's the structure for a complaint for a Mileti law. I'm sorry this video was longer than I thought. I don't know what I had in my mind that this video was going to be a 3-minute video because apparently everybody in marketing loves 3-minute videos. But just as a recap, okay? You have your preliminary statement, which you do in the end. The preliminary statement is the exciting thing that you write in the beginning that draws the reader's attention, provides an overview. You can call it a summary. You have the parties. This is the section where you tell the court who everybody is and just give a brief background. Vinny Mileti from Kings County. Law offices of Vincent Mileti, Mileti Law from Queens County. Then you have jurisdiction and venue. Jurisdiction is what why does the court have jurisdiction over this? Why can the court litigate and rule and issue rulings against these particular parties? Jurisdiction. And why this is the greatest playground for us, the venue, why this is the proper venue, why this is the proper stadium for us to have this fight in. And by stadium, I mean courthouse. Why this is the proper courthouse. Then you have the factual allegations. Remember, I like it in a very linear fashion. I like it, date, bad act, date, act, date, act, date, act. I like that. I like to group things together. It makes it easier for readability. That's the thing I really enjoy. Then you have the causes of action. Number 5. Fifth section, the causes of action. You go through every single element on the causes of action. You tie it into your particular claim, and you give what you want the expected result to be. My client needs damages. Now, so that's, what is that, number 5? I'm holding my fingers here because I can't remember, and I'm just for some reason I have no short-term memory for this. Now we're up to number 6. Number 6 is going to be the prayer for relief. The prayer for relief, you're going to simply just write out, you know, what you want this court to do. What do you pray for this court to help, to give you, to provide you, to order, so your life could be corrected and you could be happy once again. And then after that, the jury demand, number 7, because millennial likes to have jury demands. Other attorneys don't. I don't know. It's preference. I am extremely stubborn and I like things in certain ways, and I refuse to operate and function in any other way. No matter how much this one particular client who in this video fights me on all this stuff, this is, this is what I like. We're actually quite compatible. I think we're too compatible. That's why we go so hard at each other with everything. And then after that, you have, again, what I like, verification. Have your client verify. Have the plaintiff verify. What's that? 8? That might be 8. Have the client verify the complaint. It helps. It's easier. It's simple. It gives it more credibility. Everybody's happy. I'm happy. Client's happy. The dog is happy. The judge is happy. Nothing's bad in the world. Verify. All right. And then that's it. So, that's the first video, just understanding how a complaint is structured. Again, sorry, it's 21 minutes long and going. I talk a lot, but I just wanted to make sure this was very thorough and you understood everything you're listening to here, because this is important. If you are the type of person that needs to understand the rational basis of stuff, like, this is important for you, because you're not going to understand otherwise why there's a certain structure. You're going to say, you might say, well, why do you talk about this here and not here? Or why do you repeat yourself here? Why do you speak in this tone? Well, I'm not looking for this. What does it mean to pray? I don't want to pray. I'm whatever. I'm religious. I don't want to write prayer in here, or whatever the case is. It's easier when you understand it, and hopefully this video was somewhat educational. And there'll be a part 2. I think in the part 2, this particular client wanted to discuss sort of like the workflow with the courtroom of, like, a very common thing to say online is called the anatomy of a lawsuit. I don't want to say anatomy of a lawsuit because that sounds whack, and I'm a trendsetter, so I don't want to steal nobody else's shit. But let's just say, I don't know, let's just say the workflow of litigation, and what it looks like, from kind of like a business workflow perspective, from a litigation perspective. So that's going to be the next video that joins this. So thank you for spending time with me. This was a 22-minute video. This shit was very long. Hopefully you learned something. If you didn't learn something, then I don't know, watch it again, send me an email, complain to me, write something in the comments below, or whatever. Do something and just let me know. And look, as always, I wish you all the best of luck in all your endeavors. Thank you for spending time with us today and listening to our video here. I would like you to go to the website again, www.malettilaw.com, MILETTILAW.com. Sign up to the newsletter. Make sure you subscribe to this channel. At the time of writing this video, I no longer have an Instagram account. I've been banned. It happens very frequently with me. So, once we'll get social media again, you should probably sign on to that too, once we get that. But I am on Twitter, Maletti Law, and whatever. But look, we're here. We're all over the place. Please feel free. Keep in touch with us. Send us messages. Send us love. Send me clients. I am happy to take all your money, or just give some freebies here, but I definitely want your money more. Okay, well, have a great day. You as in all law, love, and lifts, and everything great. And like we always say here at Maletti Law, you know how to live, we're unusually motivated. You eat big, get large, live a great life, and when you die, leave a big basket behind. You as in law, love, and lifts, Maletti Law out. Have a beautiful day.